Item number 1. Ask to get particular. No, online. I have the statement. Yes, you got a translation. Yes, I guess you. No, it is. Item number 1.
We give a copy to the Learned State Council.
Yes.
Yes.
Yes, please. The initial email, yes, initial understand 100, the under the subsection 1, 138, 61 subsection 2 of the BNS Act, corresponding to section 302, 201, and 120B of the Indian Penal Code. The charge sheet has already been filed in the all the accused persons granted bail by the learned court below. And
Why his bail has been rejected? If all others have been granted, why his bail has been rejected?
well, they have granted bail by the law court, and I have come before you for anticipatory bail.
Oh. No, you go and surrender like all others. Why should?
The charge sheet has been filed where no purpose in this keeping him in custody.
You are one of the named accused.
Yes, yes, I am the one of the name. The recovery of murder weapon from the co-accused process. He has been named in many various 161 statements, so his role cannot be ruled out at this stage. And there is a scope of further investigation always, one. And the case hinges upon circumstantial evidence, the custodial information is indispensable. So there is scope is there is still as soon as he surrenders, we commence a further investigation. Well, I cooperate whatever the investigation of further investigation. It is not important. The charge sheet already filed, the custody of the petitioner will not may not be required. I found some of the statements where he has been placed on equal pedestal with the other accused persons who have been granted bail. under 439, my lord, and not under 438. It's a teamwork, my lord, so we need it from the.
Main prime accused is Abdul Samad.
Yes, your lord.
The others have, huh?
Yes, I have that. And it's all the part.
Procedural Mia.
The page number 13, my lord.
Page number?
13, my lord. Hafizul Mia mein page number 30, he was granted page.
Samada has also been granted.
Yes, sir. Page number 14, my lord. Page number 15, my lord. He
Someone was granted bail under, after 81 days custody, 92 days custody, and he is living in anticipation. That's the difference.
See, what is this interim bail? There is interim bail at page 14.
Yes, but he 14 in my interim.
Anyway,
But that till the completion of the investigation will be subject to certification of the SCP. Before the will charge sheet filed. Subsequent charge sheet already been filed.
But he was also in custody for some time.
And they are in charge.
Well,
The petitioner will to lock it.
Land Council.
Charge sheet already been filed. No purpose will be served.
Land Council for the state.
All the principal actions already.
These just keep saying all day, same thing again and again. I find this unique here. The moment we start dictating order, you start repeating your submissions. Charge sheet submitted, say it again, 10th time.
Not paying it.
What is this? You are here to do your job, you have done your
may I
job.
handle the city?
Not required. Land Council for the petitioner and the Land Council for the state.
But this is a case under section 365 and 34 of the Indian Penal Code. On the petitioner number 1 is the mother of the principal accused. On the petitioner number 2 is the uncle of the principal accused. And when the petitioner number 3 is the father of the principal accused. Now the allegation is that on
20th of February 2025, the minor daughter of the informant went to school and thereafter, my lord, she has been vanished and my lord. Thereafter.
What happened? She has been-
They are not the principal accused, my lord, but both of them are, she has not been recovered. She is aged about 16 years as per the Sharia law. Their majority is calculated for the marriage, that is calculated as per their majority. So that is estimated at age of 50. So
They
these
are-
are the father, mother and the uncle.
of the alleged,
Of the arrest, the principal accused is one, Alamgir Mir. क्या नाम Mir? Mia. Alamgir Mia.
oh, you have given the translated copy. He has been named.
They have been named.
No, this, the person with whom they allege that she has,
Alamgir. It's in the Nalanin.
our daughter, then we went into it.
In the last, in the portion, it's written name of the accused and address. No, in the FIR. In the FIR.
Yes, FIR translated copy is not very happily worded. It's difficult to understand. FIR is at page 11.
Page 12 is the operating portion where the name of the accused person has been written.
Such a long FIR you have given in one paragraph. This is not a translation. You give a translation. I didn't ask you to give a summary of the account.
Right. Right.
Not understand, you know, difficulty. Yes.
Number 3.
And for the statement. The last occasion, my lord, allowed me one day accommodation to come to here on particular ingredients of particular section, my lord.
FIR is in,
Yes, my lord.
oh yes, double A.
Yes.
Which provision? 46 double A.
46 double A. The important section here, the 46
That
double A,
appears to be the major,
major section, it will be the prescribing the highest punishment. In this regard, I would say, let me explain how the case started. A vehicle was intercepted with good number of spurious liquor, and thereafter, one of the two accused persons were apprehended. They were taken into custody, and leading to their statement, my lord, a godown was identified. The godown was raided, and after
1500 recovered from the godown.
yes,
Yes.
thereafter, godown and other materials.
The owner said that it is taken on rent by this accused person.
There is a deed, man. There is a rental.
There is a deed, whatever it is, but how 46 double A, that is the issue.
Madam, I'm coming to that. Whether 46 double A is applicable or not, whether if there is an attempt to mix something which is deadly or
No,
dangerous.
whether there is anything in the FIR based on which 46 double A has
No,
been
not in the
incorporated.
FIR, because this recovery was made later, madam. FIR, there will be nothing regarding this, because FIR contains the fact relating to the intersection of the vehicle and recovery from the vehicle. This is a subsequent stage of recovery, madam. Leading to the discovery.
His name has come after the raid at the
Yes, ma'am.
godown.
Yes, madam. In a subsequent stage, madam.
So where is the document relating to that recovery? What does it say?
Madam.
Was recovered from the building house of one young guy.
No. Let me. Now it is my turn, sir. My lord, here is the deed. Here is the deed.
That is not the issue. The court
The
is.
civil is my
Please
first.
try. Yeah, I have been asking you again and again.
Yeah.
Your officer has put 46 double A as one of the offenses.
Yes, ma'am.
Where is the ingredient for incorporating
Yes,
this
I'm
offense?
coming to that part.
Just show that, yes.
The samples were sent to the, sent for examination. The report is pending, madam. We have written several letters, we have written.
So pending report, you will incorporate 46AA.
Madam, whether there is anything on.
Please show what is there.
Madam, may I come?
Yes.
Madam, kindly come to section 47. Madam. Come 47 months.
Why?
47 gives a presumption.
We are asking, the court is asking you, where is the ingredient for 46AA?
I cannot substantiate.
Say so,
46A.
yes. Now what you, 47, there is a presumption.
There is a presumption. When there is a prosecution under section 46A, 46A or 46, my lord, the presumption is that the contrary, like NDPS, my lord, contrary has to be shown.
Yes, but there is no
You are-
bar to grant of bail.
My lord, there is a permissive presumption. It is your lordship's discretion.
No, but I'm not familiar with the act. So I'm
Well,
asking
here
you,
it
there is
is.
no bar under this statute to grant of bail.
My lord,
Is there any bar?
no,
Only a presumption.
only a presumption. When there is a presumption, my lord, if it is a permissive presumption, if my lord may consider it as a bar, may not.
No,
It-
never. Cannot be.
My lord's discretion. I will never
438
try
cannot
to-
be barred because there is a presumption in a statute. What are you submitting? The two have nothing to do with each other. Either there is a bar to 438
No,
or there is no bar.
No, it's-
Because there is a presumption, therefore a bar will kick in. That cannot be. A
The
very
presumption is there.
far-fetched submission. if
I
I
did,
Yes.
I made it fair, my lord.
So there is no allegation of 46AA.
Yes.
You cannot show. And what are the other allegations?
Other allegations are bottling of liquor, my lord, 46AC, 46 capital ACC, my lord. The penalty
Just slowly,
is-
46ACC.
CC penalty is up to 3 years, my lord, may extend to 3 years, 5 years, my lord.
Yes, and
And another is 46. Another is 46. C. 46 AC.
oh, you need the book.
No, I.
C is import, export, transportation, possession.
Yes. So case is in two parts, madam. One is
And
transportation.
CC is
C is the
bottle.
bottling, madam. So the godown was used for bottling and all this storage for. So these three sections are applicable.
But 46AA, there is nothing up until now, there is nothing.
There is nothing unless the report was. But the labels were fake labels. We have obtained a report from the Saraswati Press, the government accredited press, madam. That the labels on the bottles were spurious.
From where do you show?
Yes,
this? Can you show
I
that?
have.
Because
Here is the report. একটু ভালো করে ধরতে হবে না অবস্থা দুর্বল আছে স্ট্রাকচার আমরা ওদের বিষয়ে here is the report. The levels were not they were matched but they were did not comply with the standards originals. Investigation is going on. The FSL the chemical examination report is out.
I got actually on the seized article and in the vehicle and in the godown.
you think I can hear you when I'm reading?
Investigation is still going.
Yes, that is there. The labels are,
May I, madam?
yes.
The reports are available.
My lord, actually, my lord, kindly please give me the page number 18 of my application.
Yes.
Description of the seizure, my lord. Actually, there was a mention that for sale in Punjab only, and another level is for sale in Arunachal Pradesh only, right? And that actually these products, these persons they are selling for sale in Punjab only and for sale Arunachal Pradesh only products in Bengal. So this is the actual basis of this case. my lord.
No,
On the basis of a rent agreement, I think the rent agreement, there was a mentioning that
you have moved directly. Oh, there is a rejection order.
yes, my lord, at that time, jurisdiction was going on.
Right now, investigation is going on. There is no substantial.
My lord, give me an opportunity to try my luck in next cycle.
Well, it has been 2
Or
days, my lord.
My
My lord, I have,
lord, I complained.
yesterday, I couldn't convince my lord. He was very happy. He came jumping in the morning, my lord. Now he is in difficult situation.
Yes,
He's-
sorry. For land council, for the petitioner and the London State Council. There is a
For application of my bail application. Also, I could, I could find that.
I will take for the defense.
Regarding the written,
You for the effective complaint, I have for the state.
your lordship. Written complaint, running paragraph number 7 onwards. And last line of the written. Last line of the written complaint. The court has hereby restrained them from disturbing the peaceful position in respect of the property in title to number 6 of 2020. Last line.
hereby restrained them.
All the accused persons are restrained from entering into the peaceful position of the shore city shore asset land. Actually, the complainant trying to import criminal colored facilities. And an entire allegation covering the civil dispute. And whatever the question of false document or not, that should be decided by the appropriate civil.
Yes, there is a civil suit pending between them.
My lord, on the last occasion, there was a part hearing. And my lord has asked for the power of attorney, if you have collected, my lord, the power of attorney. In question, my lord, so this is the same fake power of attorney, whereas this. The fake person, Srimati Ramita Kedia, She was identified by one Vishnu Majumdar. And in the witnesses, there are two persons, Sanjay Day and Jadil Vachar. So the petitioner number two, who is the husband of the petitioner number one, he is not also the another witness of the identifier. So this is the CD. My lord.
There's nothing, no direct
Now,
involvement has.
whether this lady has a ministry or whether she knew that she is the
So
main person.
no direct
that-
material has come to connect.
Lordship,
No, if you, I will not hear you, sorry. There is no direct material incriminating these petitioners.
Kindly allow,
Sorry, you have no locus, sir. Yes, take down. Third land council, third land council for the petitioner.
This
There is a person.
Must be, must be.
Yes, yes.
you should be pending against all active spots.
All are parties there. Then, then if any restraint order, if they want any restraint order, they should have gone for an injunction. And they say injunction has been passed perhaps. So if they are violating the injunction, there is at best it is a case for invoking the court's jurisdiction for punishment.
Court has determined that those documents are paid.
No, till date.
No, we are in the civil court. Civil court has the power to determine whether these are paid documents after taking evidence.
Three Romita Delia cannot be the owner of the property. Three Romita Delia is the two. Three person claim on the Romita Delia. On the same plot. Three person. As I was saying, it's a different civil court. Whether critically it's a case. Civil case, পরবর্তী আমরা ফেলবো এরা
You have got injunction?
হ্যাঁ এরা জমি মানে কিন্তু
You have got injunction? If they have sold this land, go for cancellation of land.
Yes, heard counsel for the petitioner and the learned counsel for the state, assisted by the learned counsel.
Three 29, 3, 1152, 1172, 1182, 324, 335 of Wonderland Samhita, 2023. And the allegation is that when the son of the present petitioner crossing the house of the petitioner, they assaulted them. My lord, I am withdrawing the prayer for bail for petitioner number 5, the main accused. He has been arrested. My lord.
How is the main accused? You have a translated copy of the FIR. Give it, madam. I cannot, please.
And then I need to supplementary evidence also, because I have several documents to show that previously there is a dispute regarding a figure between the petitioner and the de facto complainant.
By Tuesday,
And
as prayed by learned counsel for the petitioner,
This case, CD is not available. In this case, CD is not available.
not good.
Item number 7.
Not good.
Item number 8.
somebody and later.
Mention on Monday morning.
Honorable division bench is available, Miller, only at 12.
Oh, yes.
There's a first appeal tender, Miller.
Yes,
Your lordship took it up, Miller, since service was not complete, though we have dispatched it, Miller put it in the next appeal. Yesterday, Miller, an order has been passed by the executing court below, Miller, for issuance of the writ. So there is some urgency in the execution proceeding. I have annexed the order of the lower court. If Miller can takes it up any day on the next week.
no, file an application. You have to file an application.
Right,
Then-
right, right,
Then you mention with the application.
right, right.
Yes.
We'll do. Great.
Number one.
My lord, in item number 1, where I'm praying for accommodation, my lord. I mean, I intend to hearing of this matter by physically, my lord. My father is seriously ill and post-operation period is in serious condition. Therefore, I am not able to go there. Kindly accommodate in the next bench, my lord. This compassionate appointment ground, my lord.
Since February, you have only taken adjournments, all the orders.
My lord, I intend to
But can the court keep waiting
matter-
for your intention indefinitely?
no,
Is this
no,
the
my lord,
way?
no, my lord.
Once you have filed a matter, you must argue it. You are there virtual, you argue it. Who is stopping you?
Yes, my lord. Kindly fix this matter in the next available bench. I will.
Sorry, no. Can't be adjourned just for the asking repeatedly, sir. If it had been the first occasion, we could have understood. You see the order sheet. One first order is adjournment, second, third, fourth,
I
fifth.
can do it. I can do it, but my intention is to do this matter in physically. Therefore, I am saying.
Come next week if you want.
Yes, my lord. Kindly.
Aspirate list in the next week. Give date of Tuesday, Thursday.
Yes, my lord. I'm grateful.
Number two.
Why supplementary? No, for orders, so it was not there.
Last one was there. For the arguments on it. List in the next week. None appears for the petition. List on Wednesday. For the applicant. Next one is.
Number three.
All the list.
Take it. Approve.
Item number four. Five. Item number six.
Item number 6, I am for the petition as well. Lordship, this matter, copy has not served upon the all the responding.
Have paid for service adjourned to the next cycle.
Item number seven. Item number eight. Eight.
Not today. Next.
Item number nine.
On the last occasion, my lord, the matter was taken up, unfortunately, my lord could not make it out. I am ready with this matter. Last occasion, I was trying to log in virtually, but I could not. Nevertheless, my lord. I am for the appellate, my lord, Food Corporation of India.
Ask him to come, he is starting. What is the issue?
Yes, my lord. The issue is, my lord, by the order of the land, a single bench, my lord, a candidate who is admittedly appeared for, my lord, EWS, economically weaker section, has been granted an opportunity to apply under the, my lord, unreserved category, and accordingly he was directed to be appointed by the Food Corporation of India. Before, my lord, I placed the judgment in, may I give the very brief, my lord, facts leading to this case, my lord, filing of the writ petition and the, my lord, the passing of the judgment in court. Well, what happened, my lord? The Food Corporation of India in the month of February 19 came out with an application for seeking appointment of various, my lord, I should say, various employees in the cadre of, my lord, engineer, technical assistants and all.
In 90.
2019, my lord, February
19.
2019, my lord. And my lord, the 30 days time was given for the purpose of, my lord, giving the application. The application closure date was March 19. So admittedly, my lord, the writ petitioner or the respondent herein applied for the post of assistant grade 3 technical. The facts are all, my lord, not disputed at me. And also, my for the record, my lord, and it is also from the admitted stand of the petitioner, he applied for the post under EWS category, economically weaker section category.
Yes. 10%.
Yes, ma'am. Under
10%. 10%.
part of 10%, I'll check.
Yes.
Yes, 10%.
Perhaps.
I'll check.
Yes.
I am not keeping that particular percentage
Yes.
in mind. So, be that as it may, my lord, the percentage is not in dispute here.
Yeah.
Now, my lord, the phase 1, my lord, examination, he passed.
EWS is horizontal or vertical reservation?
My lord, it was horizontal. All the my lord, the reservation.
Yes.
Now, my lord, phase 1 examination is common for all the candidates. It is generally English, general knowledge and all. So he my lord, passed out the phase 1 examination, and he my lord, qualified under unreserved category because of the order of merit. That is admitted fact. Thereafter, my lord, the phase 2 examination was held. In phase 2 examination, my lord, the examination was done, and in the month of January 8, my lord, 8th of January 2020, the result was published. My lord, the result was published on the same day, that is January 8, 2020, for select list as well as wait list. The rank of the petitioner, my lord, was in the select list under EWS category, ranking 3. My lord, note that once the unreserved category ends, thereafter, my lord, the reservation starts. So admitted, my lord, he has attached the whole, my lord, result sheet from which the
There is
ranking.
one thing, you said that after the first phase, he was eligible in the unreserved
No,
category
because of the merit, my lord.
because he had performed better.
He had performed better, marks was there, my lord, admitted fact.
Okay.
So he was treated as an unreserved category.
But in the final result, ultimately, he became a beneficiary of
Of
the
EW, absolutely right, my lord. Because, my lord, up to 1 to 141, the unreserved, my lord, category was there. Unreserved category ranking 141. After 141, 142 and 143 was, my lord, 2 other EWS candidates. Thereafter, one was, my lord, SC candidate, and thereafter, my lord, under serial number 147, the petitioner name is appearing under EWS 3. It is admitted fact. Now, my lord, once the result was published in the month of December, we came out with another notice for the purpose of giving extension of time for submitting EWS certificate. It is, my lord, admitted case that the EWS certificate is to be, rather the document verification is to be done once the phase 2 examination will be over. Because candidate will be shortlisted, thereafter we will verify the document.
verification after phase 2.
Phase
But
2.
at the time of online application, copy was required. to
No, my
upload.
lord, was not required, only the category is to be mentioned.
Only fill
Yeah,
up.
only he has to disclose
Okay.
his category. It is
Alright.
there, my lord. I will
Alright.
place the advertisement there.
All right.
So admittedly, he applied himself under, my lord, EWS category. Thereafter, my lord, phase 1 complete. Because, my lord, after phase 1, phase 2 will come. So under phase 2 only the candidate will be shortlisted. That is why he made the, my lord, arrangement for the purpose of verification of document after phase. Once, my lord, the time come for the purpose of document verification, there was some delay admitted. And there are other applicants also, my lord. He also applied for extension of time. Admittedly, we provided extension of time beyond the cutoff date. So beyond the cutoff date, we gave them the extension.
To
of
him
time.
also.
to him also, all candidates, my lord, for the purpose of EWS. So, my lord, the cut-off limit was extended till 31st of January 2021.
Yes.
Admittedly, my lord, the petitioner could not produce the EWS certificate once he got a call letter for document verification.
Yes.
The document verification was done on the 25th of February 2021. He attended, but he did not produce the, my lord, the document verification, my lord, the document support of the EWS category. Therefore, we came out the result that the verification is incomplete. Still, my lord, in the month of February, 4th of February, again gave an extension to produce the EWS certificate within 14th of February 2021. We gave another, my lord, extension. It is there on record, my lord. Even on the second extension also he failed or neglected or whatever, I do not know, my lord. He failed to produce EWS certificate. Now, my lord, on 9th of February 2021, he sent one affidavit. What is that affidavit? In the affidavit, he has stated himself that I could not produce the EWS certificate. Now kindly treat me as a general candidate or unreserved candidate. By that time, my lord, selection process was over. Select list and west list admittedly was published in the month of January 2020. My lord, therefore, my lord, we said by the order of my lord, our official order, that since you did not produce the EWS certificate within the extended time as well, or rather the second extended time, my lord, so your candidature cannot be considered and accordingly it is cancelled. Two candidates failed to produce my lord EWS certificate and two of the candidates' candidature were cancelled. All the order is there. Now, one of the candidates is the written petitioner who has challenged this, who has filed this petition. Now, my lord, while this matter was agitated or rather heard before the learned single bench, the learned single bench took into account two factors. One is this: first, in the phase one, he was treated as unreserved category, while in the phase two, he won't be considered as unreserved category. That is the first consideration. And second consideration is this matter. There is an official memo published by the central government of India. We are bound by the notification where it is said that EWS candidate who qualified under merit will be treated as an unreserved category. The notification is there, we are bound by it. Now the question is this, my lord, whether a person who has himself declared him should be EWS, my lord, the EWS certificate holder and later fails to produce the same, whether he can be treated as an unreserved category after the election process is over. So only few, my lord, relevant question is to be considered in my understanding. First is, my lord, whether, my lord, the selection process, after a candidate participates in the selection process, and once the selection process is over, whether he can challenge the selection process. In this case, he has not challenged the selection process. Second, my lord, it is, my lord, is a common maxim or rather the other that the rule of the game cannot be changed after the game starts.
Those issues don't arise here.
Yes, my lord, it is arising. Also from the advertisement because he deferred to do that. It
Deferred?
is specifically mentioned from the advertisement. Various clauses are there. That once you declare your category is to be very selectively, and once it is declared, you cannot change the
Rules
category.
of the game cannot be changed midway applies to the employer, not to the employee.
Yes, my lord.
So it
Yes.
does, you are not trying to change it. Therefore, it does not apply. That has no application.
Whether, my lord, the same person considered.
Only thing is when he has applied in a specific category, is if he has failed to provide the certificate for the same, then he will have to suffer the consequences contemplated for such circumstance in the advertisement.
Yeah,
That is all.
I have told. Only in my understanding. I have
If
not
there is a circumstance that such persons will only be allowed to be considered as unreserved, then he will be in certain employment advertisements. They say that if you fail to provide, then you will be disqualified. In some they say if you fail to produce, you will be considered as unreserved.
Absolutely.
So what is the?
Yes, I saw that.
That is
I have two other aspects. I mean, I have two other points. And fourthly, my lord, whether my lord, he has challenged the selection process
He
or
has
the
not.
order of cancellation.
He has not challenged.
Okay, very well. And fifthly, my lord, whether this particular honorable court, the rather the landed single judge, my lord, has the territorial jurisdiction to entertain the writ application. Admittedly, no part of the cause of action arises in the within jurisdiction of the honorable court. He had applied under.
This cannot be taken before the revision.
Very well, my lord. Let me, it is a settled position, my lord. If the law does not apply, if no part of the cause of action arises within this part, my lord, therefore there is no waiver applied. My lord, no, there is no waiver against the law of the land. So no part of the cause of action. Why I am saying so? Because, my lord, all the parties because my lord, the food corporation of India has 4 zones, north, east, south and west, or another 5 zone, north east. So he has applied under north zone, and all the my lord, the respondents from the first title, it will appear my lord, north zone is from Noida. So all the authorities in Noida have been made a part. So that is the my lord fifth consideration. But so far the my
So
lord,
everyone who challenges the process, they have to go to Noida.
well, in the Delhi High Court, my lord, because my lord, the no
So
part of-
applicants can apply from anywhere in the country. But
But-
for challenging, they have to go to Noida or Delhi.
Because he has chosen the north zone. There are, at the time of application, they had the my lord, option to select the zone my lord. This particular petition had chosen north zone. He could have selected east zone my lord. The east zone falls within this jurisdiction my lord. We have a zonal office in Kolkata my lord. Certainly my lord, east zone comes within this jurisdiction. But so far the north zone is concerned my lord, that is beyond our jurisdiction. That is my lord the fifth leg of my argument. Now, my lord, if I may I kindly play the advertisement.
And the principles contained in section 20 CPC have been incorporated in article 226 or not?
Yes, my lord, but any part of the cause of action will have to arise.
Therefore, examination being conducted is not part of the cause of
It
action.
was online, my lord. It was online exam. No, it was not a, my lord, the physical examination was done in particular center. The examination was done in, my lord, online. The verification was also done in our north zone, my lord, that is my lord, Noida office. The parties all are made from the question it will appear, my lord, all are from the official in north zone having its office in Noida. Now, my lord, what are the, my lord, the rules of this, my lord, particular selection process? May I place, my lord?
No, just show us what is the first phase result. First show us the first phase result.
First phase admitted, my lord. It is there.
Where is it? Show us. What has the Honorable Single Judge directed?
It is interrogatory.
Yes.
When
What is the directive?
When it was first taken up, Justice Bhattacharya in the single bench were granted as an interim order, asking them to keep one seat vacant and not to fulfill that.
That is
That
there,
is
my lord.
Justice Bhattacharya's order.
It is there, my lord. It is.
And
we are not
thereafter-
telling.
We are asking you what is the direction
Granting appointment.
to appoint.
Recruitment of-
So the argument that by that time selection process was over is incorrect, because when the interim relief was granted, the appointments was not over.
What are the
Only the
selection process?
document verification was over, not the appointment.
My lord, once the results comes out, my lord, the selection, it is settled position of law, my lord, the selection process gets over when the results comes out. That is the phase two, my lord, the selection. My lord, may I place the advertisement so that my lord I can place the whether it is eligible for this or not.
So one post was kept vacant.
Yes, ma'am. Thereafter, only the final order came for the directing us to give the appointment, challenging that judgment, my lord, we have come before your lords. My lord, the advertisement starts at page number 219. My lord. In the my lord that form. That is a fair copy, my lord, that we have attached. We have attached the writ petition also. There also it is attached. My lord, that copy is little. It's not so fair. So I am submitting from the advertisement that you attach without the application. That is, my lord. It starts from 219, my lord. And the my lord relevant page, my lord. If I being your lordship kind attention to page number 223. The relevant clauses which is applicable to the EWS candidates. May I start, my lord? 223, my lord, the top paragraph. EWS vacancies are tentative and subject to further directives of Government of India and outcome of any litigation. The appointment is provisional and is subject to the income and asset verification being verified through a proper channel. And if the verification reveals that the claim to belong EWS is fake, false, the services will be terminated forthwith without assigning any further reasons and without prejudice to such further action. It may be taken under the provision of Indian Penal Code for production of fake or false certificate. The income and access certificate issued by one of the authorities mentioned in the prescribed format as given in Annexes C shall only be accepted as proof of candidate's claim as belonging to EWS. So therefore, my lord, the furnishing the certificate was mandatory, and in the event the certificate is found to be false or fake, we can cancel the candidate of the candidate. Thereafter, my lord, kindly comes to 236. My lord, page number 236. Clause 7. Options should be exercised by the candidates carefully after going through the advertisement and keeping in view fulfillment of eligibility conditions. Educational qualifications, experience, etc. prescribed for the post of option once exercised shall be final and no change will be allowed under any circumstances. So, Mara, this particular clause specifically diverts the candidates from changing the category once he applies under one particular head. Page number 236, my lord. Clause 7.
Reserved.
There is no reason there.
Theory becomes an reason.
Comes under these are absolutely.
Okay, reserved.
That is how. Because. 7 months.
Yes.
Yes. Clause 7.
No. He's been appointed already.
No, man.
You have not complied with your.
Well, thereafter, my lord, contempt proceeding was initiated because of this pendency of this appeal, my lord. Then, in the rule was issued, then we challenged the rule before the Honorable Supreme Court. So, the Supreme Court has put on hold the contempt proceeding. So, in other words, my lord, this landed single judge bench order is
Judgment has not attained finality, therefore you have not complied.
Yes.
This is your stand.
Yes.
Yes, let's.
Yes. 236, my lord, may I read again?
Not required, those issues are not in dispute.
No, because.
Those issues that you are saying, there is nothing in dispute.
Now the question is this, my lord, now the landed, may I then again, well, may I 2 or 3 clauses, only to show that.
You may, yes, we are not stopping you.
My lord.
You may.
Only to, my lord, show that this is so, why you are harping on.
These are standard clauses in every selection
Yes,
process.
absolutely,
This is
my lord.
nothing
And
unique.
here, second position, my lord, one the option is, my lord, taken.
You have to be careful. You have many advertisements, they require that you should be in possession of the certificate on the date you make application.
Right.
EWS, that cannot be insisted because EWS category changes every year.
Every year. That's
So
why
therefore,
cut-off date is very important.
that is,
the-
these are very normal things.
Absolutely, my lord, bow down. Absolutely. In this case, my lord, cut-off date was March 19, which was the date of closure of the.
Every financial year you have to give a EWS certificate.
In this case, my lord, we have kept that particular date as final and admitted, my lord, the candidate has specifically mentioned that you will not produce EWS certificate. He only asks for his consideration under wait list. Now the question is this: his name
Because in the wait list there were persons having number below him.
below him, but those persons, my lord, first you have to see the whether he is eligible to be considered both under the select list as well as wait list. Because once we consider him in the wait list as well, then my lord his candidature under select list goes because he has his my lord candidature is already once considered. We have considered under select
So
list.
in one category he is in the select list.
Yeah.
In the other category he wants to be in the wait list.
Yes.
This
At
is
the
his.
same at the same
This is his case. He
This
wants.
is his case.
He wants to migrate from the select list in the reserved category to the wait list of the unreserved.
Unreserved category.
Because in that list there are people having lesser marks than.
Yes, sir, but the EWS and general category we have already submitted this published the result. Now another
You
question.
have published the result, but the point is he is not going to displace anyone.
Well, certainly he may because already.
How can he? You have kept a seat vacant.
So that is because of the order, my lord. Now if
So,
the order goes.
so practically he is not displacing anyone.
My lord, if the order goes, my lord, then that is the interim order. The interim order will also go.
Correct.
Because that is under challenge before your lawsuit.
That is all right, but we are saying it's not your case that he is displacing anyone.
But maybe, my lord, I have to check that whether the ranking somebody will be displaced.
What you mean check? Either you have said or you have not said. If this is a ground taken, it is taken. If it is not taken, not taken.
Interim order, we are not dealing with this because we have challenged the main judgment itself. That is the appointment.
All right, let's see.
Yes, my lord. But all those similar clause may have placed.
You may.
237, my lord.
Yes.
Clause number 11, at the application stage, the scrutiny of eligibility category and other aspects will not be undertaken before issuing call letters for online test. However, the fact that the call letter has been issued to the candidate does not imply that his or her candidature has been finally cleared by FCI. Would be free to reject any application and at any stage of the process, cancel the candidature of the candidate in case it is detected at any stage that the candidate does not fulfill the eligibility norm. In this case, admittedly, my lord, EWS candidature was not established.
Yes.
Thereafter, my lord, kindly comes to page number 240, my lord.
240.
240.
Yes.
I have a ready note, my lord. After my finishing a submission, but I can produce only highlighting the relevant clause.
240 which provision?
My lord, 18, my lord.
Shortlisting.
Shortlisting in the online test and skill test for the any post without fulfillment of eligibility condition will not confer any claim to the candidate for final selection.
Yes.
Thereafter, next page, my lord, 25. Issue of admit card, call letter to the online test, skill test, document verification does not confer any right of acceptance of the candidature and should not be constitute as an acknowledgement of fulfillment of the eligibility criteria. At the time of document verification, the honors will ensure that documents brought by the candidate are complete in all respect and as per the requirement for the concerned board shall lie on the candidate. The documents are subject for further verification. Now, my lord, the 243. There has to be a written declaration, my lord, so far the category of that particular candidate is concerned, my lord, we have given a format. My lord, Roman 4. Under clause my lord 2, Roman 4. The text for the handwritten declaration are as follows. I, such and such, hereby declare that all the information submitted by me in the application form is correct, true and valid. I will present the supporting document as and when required. The above mentioned handwritten declaration has to be in the candidate's handwriting and in English only. We have also, my lord, given another additional emphasis because this declaration is not to be printed. The candidate will have to, by his own writing, have to declare that the whatever information he is providing is all, my lord, correct, and he will, my lord, produce the necessary documents support thereof. Thereafter, my lord, 247. My lord, there is one box. The action against candidate found guilty of misconduct or use of unfair means.
How this will apply to his case?
My lord, if furnish any particular that are false, it is mentioned, my lord, the first line, if any particular that are false.
During the examination,
But he has
not in the application. This does not apply. Use of unfair means is always during examination. This will not apply.
My lord, while submitting online application, it is mentioned.
Where is it?
Yes, my lord. May I read? Candidates are advised in their own interest that they should not furnish any particular that are false, tampered with, or fabricated, and should not suppress any material information while submitting online application.
He is not submitted. He is not.
He has
Suppress-
submitted the application, my lord. I will show from this.
When the application was submitted?
Well, within the cutoff date.
When?
Date, I have to check, but the last date was March 2009.
19.
Yes.
Now, if he fails to give us EWS certificate in 21, how it can be? They are
but the
2
relevant-
financial year apart.
Yes, my lord. But the
Yes.
relevant period is still for those periods, my lord. We are giving the time to produce the document.
But
not
for
the
that year only.
Yes.
2019, 18, 19.
18, 19, 19, 20. 1920 and financial year 2019. So
Okay.
cutoff date it is matching, my lord.
All-
But the relevant years we are asking for that matches with the date of closure of application. Now, my lord, kindly see when the result published, his rank came another serial number 143. So up to 1 to 40, 141, my lord, all the candidates were taken unreserved category, irrespective of their, my lord, category.
This
because
is
of
the
merit.
final result.
Yes, phase 2, my lord. That is the phase 2 result. It is because of the merit, my lord, irrespective of their category, they are treated under unreserved. And if, my lord, we scrutinize that list, my lord, we can find, my lord, actually 12 EWS, my lord, candidates who applied, my lord, under EWS category,
Why not?
but qualified
Very-
under merit.
Very common. There
Yes.
may be BC, there may be SC also.
SC also, but I
They
am
all
concerned
may
with
be there.
EWS. In this case, I am concerned with EWS, total 12 EWS.
In any selection recruitment process, merit has to prevail.
Yes, yes.
So if
Merit-
by virtue of their merit, they cross over
they
to the
cross-
unreserved,
yes,
they
that is
can,
why.
other way it can't be.
Yes, otherwise can't. That's right. So in this case, my lord, the last mark which I can get from the list, my lord, 101. Like the last PWS candidate who got 101.25, who qualified under unreserved category. And in this case,
At 101.
101 out of 240. 1.2.5, my lord, I checked, but it is there. And he admitted his marks are 99. So under 99.25, 2 candidates were there under EWS, so they became EWS 1. Another was same mark because the seniority, he became EWS 2, and his marks were 99, so he became EWS 3. So my lord, he did not qualify the merit. Though he applied under EWS, now he did not qualify the merit. Now he is taking charge under waiting. That is not permissible from the various decision and from the advertisement that I can, my lord, lay my hands on. Now, my lord, kindly see the prayer one of the repetition. That is also very material.
Where is the result? You didn't show the result.
My lord, the list is there, my lord.
Where is it?
Very good. The list starts at
The final result. Second.
phase 2. Yes, phase 2 result.
Yes.
My lord. My lord. It is the part of the repetition, my lord. I am relying upon their repetition only, my lord. It starts from page number
What is
63.
the date of phase 2 result?
My lord, 8 January 2020. 8 January 2020. The select list as well as wait list were published.
Which page?
My lord, it starts from 63. It is my lord little illegible, I must confess, and my lord I beg to be excused. I will assist your lordship, but it is admittedly very difficult to read.
He's at which serial?
Yes, my lord. His name is appearing, I am showing my lord.
Forward, what is it?
My lord, running page number 72. 63 also, my lord, can say it is little fairer copy. That is the only page, my lord, relating to him, my lord, page number 63, serial number 147, my lord. My lord can see the candidate name Saurabh Roy, category under which the candidate applied under application SC/ST EWS. EWS is showing, my lord, marks obtained 99. Thereafter, my lord, the right hand last column EWS 3. That is my lord, serial number 147. And if, my lord, I go by the whole list, then it is serially, my lord, it is there. That is, my lord, running page number 72. That particular page only dealt with the writ petitioner. And thereafter, my lord, the list starts from page number 64. And on serially, his serial number appears at running page number 72, my lord. Left hand side 147. This particular page was not so legible, my lord, so that is.
Unreserved stops at 143.
143
143 is the last unreserved category.
Yes, absolutely, Mara. That was last, and the marks were, let me tell Mara, the marks were 99.50. And the last EWS candidate, what I can see from this list, my lord, the last EWS candidate was under ranking UR 138, and the marks obtained, I wrongly said, my lord, 99.75. That is few columns above, my lord.
Last UR category is serial 143.
143, yes, my lord. And that was, my lord, serial 140, my lord. That is the last EWS candidate who qualified under merit list.
Serial 1?
My lord, serial number 140. 1, 2, 3. 3 serials above, my lord. 143, thereafter 1, 2, 3. Third from the serial number 143. And the ranking, my lord, it is not so legible. The ranking is UR 138. And marks obtained, my lord, 99.75. And the UR, my lord, ends at serial number 143 and unreserved ranking 141 with marks 99.5. 99.5. With marks 99.5, my lord, the unreserved category ends from the selected. And he obtained, my lord, 99 marks. And my lord, from 1 to 141.
What is the marks obtained by 143?
143, my lord, 99.25. Both 142 and 143 obtained 99.23. And sorry, 99.25.
So according to his merit, he would not be placed.
Under the unreserved, that is why, my lord, according to EWS category, he came under third.
He has 99.
He had got 99 under the select. Now, my lord, when after two successive occasions, the extension, my lord, he could not comply. Thereafter, after 2 long years, my lord, the application closes on March 19. In February, my lord, 21, he sent that application, that other an affidavit stating something. My lord, may I place that affidavit whereby my 40 change the category?
Last date for submission of application was?
Was 30th March 2019.
For application.
For application, closure of application. Once a date of application closes, the
What is the date?
31st of March 2019.
31st.
30th March. Let me take a second. Closure of 30th
March.
30th March 2019. It starts from 28th February 2019. So around 1 month's time was given to the for the purpose of application. And my lord, the result came 8 January 2020, and in February 2021, my lord, he filed that, rather sends that, my lord, affidavit asking for the change of
No,
certificate.
so
May-
result came in the January 20.
January 20.
They were required to produce the certificate by which date?
The firstly, one extension was given up to 31st of January
What is the first date on which they were required?
31st January 2021.
31/1/21.
My lord, before that, my lord, may I submit one thing that when the letter for my lord, document verification was sent to him, that date was 25th of February 2021. On that, he failed to produce. Thereafter, he provided.
That is what we are asking. What is the first date?
I'm sorry, my lord, 25th of February 2021. Hundred and one, my lord. That was the official call letter sent to him seeking call letter for document verification, and the date for my lord appointment was given to 25th of October, 25th of February 2020. 25th of February 2025.
Page 101.
Then page 101. Since my lord he could not comply this document rather did not satisfy the document verification, so we my lord the result for the purpose of incomplete document verification is at page number 267, my lord. In 267, our official communication is there stating that the document verification was incomplete. It starts from 266 and ends at 267.
So a list has been published.
Yes. List has been published. Only after the publication of list, the shortlisted candidate will be called for document verification. He has already declared himself EWS. We are all impression, my lord, you establish the candidate by supporting document. Otherwise, why you mark himself under EWS category? 266, my lord, we have given a tick mark under the heading incomplete.
25 to 2020, you said 21.
No, my lord, 2020.
So this is the first date
This is the first date, my lord, officially. Thereafter, my
at
lord,
page 266.
266 is, my lord, the outcome of the document verification. That is 267, my lord. My lord, you kindly see that the bottom, the document verification ticked as under the heading incomplete. Because he could not admit, my lord, situation that he could not produce the EWS certificate.
Yes.
Now, my lord, in December 2020, my lord, we came out and notice given an extension to all the EWS candidates to produce the certificate within 31st of January 2021.
Oh, December, what is the notice date?
My lord, notice dated is 24th December 2020. That is at page number 268. That is the first notice, my lord, we gave 24th of December 2020, giving the extension of time to all the EWS candidates to produce EWS certificate by 31st of January 2021. My lord, that notice is page number 268.
But it did not entail any consequence for not submitting.
We are giving a last opportunity, means, my lord.
Where have you said last opportunity?
But this was the communication of the official communication, my lord, whereby, my lord, this is directed, my lord, it is internal, my lord, communication. It is directed to the executive director and sent by deputy general manager. So far the notice to him is concerned, my lord, that is at page number 137, my lord. It was, my lord, our internal communication to show that the date is extended. And so far the notice to him is concerned is page number 137.
Four one 2020.
For 1/20/21, my lord. Several representations were received from candidates who failed to submit valid EW certificate for the year 18-19 in respect of recruitment of category C post against advertised number such and such. Highlighting difficulty of application. In FTA follow the government visa regulation guidelines in the matter of reservation. The matter was examined in consultation with MOC such and such DOPT. Accordingly, it has been decided that EWS certificate valid for the 1920 apart from 18-19 issued beyond the closing date of application will also be considered. The candidates were not able to submit the appropriate EW certificate as stated above are allowed time up to such and such, that is 31st of January 2021, to enable them to obtain and submit the certificate stating that he or she belonged to EWS category during 18-19 and 19-20. The certificate valid for the year 18-19 should be issued on the income basic income of the financial year 17-18, and the certificate valid for the year 19-20 should be issued on the basis of income for the financial year 18-19. The list of candidates who did not produce the valid EW certificate is given below. All the candidates shall submit self-attested copy of documents via their registered email ID such and such. The original documents shall be produced for verification at the respective location, which will be intimated by email to all the concerned candidates. The appointment in respect of such candidates shall be provisional and subject to verification of EW certificate as per rules of extant instruction. Thereafter, my lord, the names of those candidates are given. His name is appearing at CL number 15, my lord. Gaurav Rai, AG3 technical. Now, my lord, he did not produce this certificate. Then the final opportunity we gave by way of an email, that is page number, my lord, 100. That is the last one, my lord. Notice dated 4th of February 2021. Page number 100.
Yes.
Email dated, my lord, 4th February 2021, my lord. Address to it is mentioned on the top left hand side, Gaurav Rai, at the rate.
Yes, this says last opportunity
Yes. Now the last opportunity is,
in February.
yes.
But
We have
there
given him,
was
it's not that he on summary basis rejected his candidate. Now, my lord, may I go to that affidavit? I do not know how instead of representation he sent affidavit, but nevertheless, whatever it is there, my lord. 104. On which basis, my lord, he was given an opportunity under the order of the commission. I, Saurabh Rai, son of such and such, that I see Saurabh Rai, Sapon Kumar Rai, son of such and such, have applied in EW category for the technical trade such and such, advertisement such and such. That due to COVID.
Where is that? Where is that?
Oh, I'm sorry, man. 104, man.
Yes, you need not read.
It is there, man. That is only two paragraphs, my dear.
Read.
Last two paragraphs. That I did not avail any third paragraph, rather. That in this regard referred to DOPT Government of India notification such and such. In case of direct recruitment, SC, ST, OBC cannot be denied who was selected on the basis of on the same standard as applicable to general candidates shall be treated as a merit candidate. We are not disputing. Had you obtained the marks beyond 99.225 miles, he could have been easily qualified as an under the unreserved category. We are not disputing. Since he did not qualify on merit, that is why his ranking came under EWS. It's not that he by choice or by ranking also. Still, he was eligible to EWARD, but we have not given it under EWARD. He was, because of the marking only, his ranking came and EWS given. Now, thereafter, he is relying upon the same notification and said, since you have notification is already there, now you pick me as a wait-listed candidate under the EWARD category. That is impermissible.
What is the date? Wait list was published on the same day.
Was in the same day, madam. And madam, kindly see that is very interesting thing, but kindly see the prayer made in the writ petition. But I could not find the madam in my humble submission, I could not find it proper, madam, the relief sought for in the writ. Kindly see that is madam, page number 21. The writ of writ and proper in the nature of mandate who issue directly the responder authority and his main agent advice officer
All right, we have seen.
under the unreserved category of the select list, madam. He has mentioned under
We
the.
have seen it. How many times you will say the same thing, repeating the same thing again and again? Yes,
But I will just,
he has not finished. Wait, yes.
I'm sorry.
And may I produce my decision in my submission?
Yes, what is your submission?
Submission is this, madam, once a candidate participate in the selection process, he cannot challenge. He is trying to challenge because we have given him in a position under the select list. Now he is asking for a wait list. That is not permissible. Secondly, rule of game, he is trying to change it, madam, at our behalf. Now treat me. If I treat him, madam, under the wait list, then the game of the madam, rule of the game would be changed. If I accede to the demand of the petitioner or madam, the order of the land is single bench, so that would amounts to madam change of the rule of the.
Those issues don't arise here.
Thirdly,
Those issues don't arise.
madam, the official memorandum that the land single judge has relied upon, may I produce that memorandum?
What is that memorandum?
May I produce that one clause? May I read, madam?
That is a very standard memorandum. That is the law of reservation.
Regarding EWS, why?
Regarding every reserved category, merit has to prevail. If on the basis of merit they are liable to be considered as unreserved, they must be considered as unreserved. But in this case, again, you will say 99.2 was the last, he has obtained 99. So therefore, he doesn't have.
And the memorandum was not general, madam, that memorandum was specific.
Memorandum is not for this circumstance. The memorandum is.
Land single judge that relied upon, that is why I am trying to submit.
Yes.
Because land single judge only on that basis, madam, he passed the direction under challenge. May I, madam?
Once the last opportunity has been given for submitting the certificate, then only he has come out with a plea that you change my criteria. Till the last opportunity was being granted, he has said nothing.
And even if madam, that is permissible or not, I will try to submit madam on the decision.
That is something you may, what decision, whether it is permissible or not.
No, no, because several cases, that is the rule of the game, that is to accept this matter. I will not, I will just produce matter, but I will not read that. Another one that matter, the Rajasthan judicial quota matter, category matter, there also similar situation happened. Few of the candidates or several candidates applied under EWS category. Within the due date matter, they could not produce the certificate.
Yes. Which judgment you are relying?
Malas, first is malas, no, very well, malas, the rule of the game cannot be changed. I am not referring to since I have brought me. Relevant paragraph malas, 15, 18 and 22.
Change is something which applies to the employer. How a candidate can change the rules, sir? Why don't you understand? Rules of the game will always change by the employer.
What I am trying to
If
submit
this
is-
law is only applicable to the employer, this does not apply to the employee.
Not apply, but if I accede to this, if I acceded to this request, then the rule perhaps would have been changed, my lord. If I exceeded, suppose my lord, because of the affidavit should
So
allow.
your rules and advertisement does not permit. Where is the question of changing? Your case is that your rules and advertisement is clear. You claim a particular category, you have to substantiate. If you don't, you are disqualified. Where is the question of changing the rules of the game? These issues don't apply. What other judgment?
My
So
lord, here, my lord, on the last cut-off date, the candidates could not produce the EWS certificate.
yes, show that one.
That is a proven decision, my lord. And then, that's what,
Yes,
may I read the first paragraphs of article?
13. 13 or 30?
Party.
High Court directed for balancing the equity and treating him as unreserved.
Yes, so because of the minor the even after the passing of the cutoff. The
Yes.
Supreme Court did not allow it because admittedly within the.
Where is that? Where is that?
13 I was relying upon to reach the case minor.
That we have seen. So what the apex court held?
17, 18 minor. There is
Yes, you may read.
page number 5. Undoubtedly, when the status of a candidate belongs to scheduled caste, scheduled tribe, determined by what the one part, however, they are also unable to being SC candidate, status of candidate will be OBC, MBC, NCL, and EWS must be subject to.
OBC, SC, ST, they fall in a different category from EWS. OBC, SC, ST, Ram Kumar Gijroya's case is there with the apex. Gijroya's case is there where the apex court has held
Even after the
that
cutoff date, he will qualify.
once OBC, always OBC. EWS, that will not apply. EWS is for 1 year only. In one financial year, one can be economically weaker, in the next he may not be. That will not apply.
After the court has dealt with.
Yes.
The later part. OBC, NCL with non-criminal, NCL or EWS is constantly subject to transportation, political, social and economic sector. What my lord has just, my lord. It's on the strength of this reasoning that the decision of 9th decision, the court of Indra Sani has been mentioned. In tracing this footstep, numerous decisions subsequently rendered by this court crystallize the dynamic nature of status of other backward classes as against that of SC/ST. Moreover, the court is subsequent decision of attention. Paragraph number 21. The
Yes.
circular dated 9/9/15 notified that a certificate for NCL non-criminal category shall only be valid for a period of 1 year. Moreover, it is a case that the concerned applicant has not translated out of the said category the following year. An affidavit by him has provided in affidavit to allow him to initial issue certificate to deem as valid. However, the maximum period to allow for his practice to continue is 3 years. Thereafter, my lord, this advertisement has been reproduced. Then the court is coming to the conclusion. But similar clauses were also there, that before applying.
Those are very standard clauses
Yes.
in every recruitment.
Like tender document, my lord,
Yes.
standard clause, yes. Thereafter, the court comes to the finding. Paragraph number 26. The
Yes.
advertisement appears to be silent on the aspect of last date of issuance of valid category certificate. However, clause number 1 and 3 of paragraph 6 explicitly provide that all candidates from concerned category therein was to furnish certificate issued by the competent authority as per rule. Thereafter, a collective reference to clause 1 and 2 of paragraph 18 attracts our attention as it is clarified that candidates could only apply under a state category if they meet all the eligibility conditions as per the advertisement. Next paragraph. On the subject of absence of last date to showcase the eligibility by a candidate approval their equivalent claim, this court clarified the correct position of law in the decision of such and such, while after opposite the view taken by High Court of Punjab held that the eligibility criteria for candidates aspiring public employment shall be determined pertaining to the cut-off date as outlined in the applicable rules of their respective service. In case the rules are silent, the decisive date is ideally indicated in the advertisement for recruitment. However, in case of absence of specification in both contexts, eligibility is to be adjudged in view of the last date of the submission of application before the concerned authority. So it is
That is also settled law.
Yes.
Eligibility is to be with effect from the last date, closing date for application.
Now, my lord, my lord, packet of the decision, the court has given the list of the candidates who did not produce the certificate within the due time. The court says above details would make it clear the name of the application had a valid certificate and were accompanied by an affidavit as per the proforma at the relevant time as per the requirement as stated above. Significant delay, although the correct position of law is not in favor of the applicant before us, and relying upon the decision that provision of law property circumstances before us, the appeal ought to be declared devoid of merit, considered equitable appeal while according the reason and double use. Therefore, this candidature was my lord, who was submitted the decision for this.
Oh, here also Ram Kumar Gujroya has been
Yes,
considered.
yes, but that's it. That is my lord, absolutely. I also thereafter gone through the decision, my lord, on the cross.
The apex court has affirmed decision of the Delhi High Court. That was decision of the Delhi High Court regarding OBC. Yes.
Now, another decision, my lord, Supreme Court decision, in this case, the situation was little different. The candidate was applied under general category. Once he failed to my lord, qualify, then he applied for under the reserve category because he said I was entered. Though it is little vice versa, but nevertheless the court has come to a finding. So once you apply under one particular category, it cannot change. It's a very short decision, my lord. I will just read one paragraph. But it is a other way around. In this case, he was under reserve, applied for unreserved category. In this case, he was unreserved but applied for reserved category. I will read my just the last paragraph, paragraph number 5. We have considered the rival contention advanced by both the parties. The contention of the first respondent cannot be accepted as he has not applied for selection as a candidate entitled to get reservation. He did not produce any certificate along with the application. The fact that he has not availed of the benefit of the preliminary examination itself is sufficient to put him as a candidate not entitled to get reservation. He passed the preliminary examination as a general candidate and the subsequent stage of the main examination he cannot avail or reserve reservation on the ground that he was successful in getting the repeated certificate only at a later stage. The nature and status of the candidate who was applying for the selection could only be treated alike, and once a candidate has chosen to opt for the category to which he is entitled, he cannot later change the status and make it case. That is the last paragraph. The decision bench was not correct in holding that as a candidate he had also had the qualification and the production of the certificate at a later stage would make him entitled to seek reservation. The court, my lord, nullified this, my lord, act.
Which category he was claiming?
But maybe there are the reservation, like this.
Resident of the state of Jammu Kashmir.
Domicile.
Domicile.
Reservation based on SRO, number suggestions.
SRO would be domicile, state resident.
But he was seeking reservation, my lord. Without going under the category, he was seeking reservation that my lord, the court did not permit.
That is impermissible.
That is impermissible.
General can't go into reserve, but reserve can go in general.
On merit matter.
So therefore, this judgment is for
So change
the
of category.
proposition.
Yes, I have shown that changing of category is not permissible after the result was published. In this case, man, after the publication of the result. Because once he did not qualify, thereafter he was sought to change the under the reserve category. Another, my lord, in this case, my lord, it is a written decision. In this case also, he was a general candidate, but sought to change under EWS. So here also the court did not allow. It is a decision judgment of my lord Rajasthan High Court.
All these judgments are from general to reserve cannot be permitted under no circumstance. Reserve to general can be permitted in some circumstance. General to reserve under no circumstance.
Yes, that is true. Why I am submitting?
Certainly.
Because all after publication of the result. And on that ground, my lord, the court was reserved.
Even if prior to publication of result, can it be done?
No. Then he could have applied under the reserve category.
Therefore, these judgments are for the inverse situation.
Very well.
I don't know why you are referring to. Your case is simply that there is the recruitment process is initiated, guided, concluded under the terms of the advertisement. He has, with open eyes, opted for a particular category. There is a clear and specific stipulation that if you ultimately do not satisfy that you possess the category, the same will entail adverse consequence. Therefore, he cannot get anything better.
Yes,
This is your case.
that is.
Yes.
And he did not, my lord, make any specific prayer also in support of his case.
Where? Before the writ court?
Yes, it.
No, he has made a prayer.
But select, you are saying, treating on a select list, my lord. You are now asking for wait list. To select list, he is not qualified, my lord.
He did not pray for wait list.
Yes, my lord. And it is a prayer select list. You are asked for select list. That is why I require.
And if he prayed for wait list,
Huh?
would that make him entitled according to you?
Select list, he is not entitled anyway.
If there is an omission to make a prayer for wait list,
It's not, my lord. But any prayer is also not there.
so that is the writ court can mold that relief. If he is found.
But you are sought for, neither was sought for, nor.
What liberty? I need, this writ court needs liberty to mold the relief.
No, but at least some prayer should have been there, my lord, that the.
If the prayer is there, where is the question of molding?
No prayer is
It
there.
is only when prayer is absent that the writ court can mold the relief.
If you are not there, my lord, I am trying to.
No, that's all right. We have pointed it out. We had missed that.
And my lord, only to show that the relevant clauses, I was carrying what, no, if my lord allows, then I can serve. Only to have a ready reference, if my lord desire.
The relevant clauses.
Ah,
You have just shown page 123, 22, 36, 237, 240, 241, 43, 47. All we have marked. Don't worry.
List of dates also is there, if my lord.
Not required. You may give if you want.
Still on the back page, my. Ready reference is there, only to show that.
That's all.
Yes, my lord.
We'll hear you after recess.
Yes.
all the orders.
Come this side. They have dismissed your appeal.
Great, Lord.
Now you go back that side. That is the. Yes. Oh,
And I was in this site with Mr. Rahman for almost 5 years,
Yes,
till 2023.
you are in the state panel.
still?
2023.
What this happens? All of us have that privilege as long as we are there.
If Millard kindly takes Millard the last document of the paper book, that is Millard the observations of the coordinate bench while rejecting their application for stay in this appeal. That Millard summarizes my argument. So I'll place that first.
Last,
Last document 276. Page 276. Millard, I'll just read it out, Millard, the second paragraph on.
the stay was taken up before a division bench.
Yes, by this coordinate bench of this court. And the stay was rejected with adequate reasons. I will place that, Millard. The
But this is stay in these proceedings.
stay in these proceedings.
But
While-
then they have already got an order from the apex court.
Well, that's
Against
with
the
regard to the
contempt.
contempt. Against this stay, it has not been carried before the Honorable Supreme Court.
No, no,
So
but
as the
if,
contempt is
what is the
concerned-
effect once the apex court says that
The contempt has been stayed.
when
Till
contempt
pendency of
cannot
this
proceed,
Now,
then
this
that
specific
means
direction, my lord, I am not getting
that,
the.
that means they are not
order is
required.
not to be carried out.
Yes, Millard, I'll just.
You have got a copy of that order.
Well, I can, my lord, right now it is not there, but I have seen that order, my lord.
You should have given us copies.
In course of this day, my lord.
You give him also.
Yes, I will give you.
Millard, I am also
It is
not
very
aware
fine.
what the Honorable Supreme Court has observed because we are not a party to that.
With responsibility. I
You
will-
give a copy.
My lord. In course of this day, my lord. I will.
Then you make your submission on Monday.
On Monday, Millard, as you, Millard.
My lord, on
Go
Monday,
through the order.
my lord, I.
Yes, yes, yes.
Well, on Monday, I am coming from Kolkata. If on any other day, then I can arrange.
Millard has
You
extensively heard-
have argued everything. He will make his argument. If there is any reply, why don't you
Then
join us?
Tuesday at least, so that online I can remain present at least.
Tuesday is not a problem. We can have it on Tuesday.
Tuesday.
You give him a copy.
Had it been Thursday, then my I could have come.
You said Tuesday is all right, so Tuesday we are fixing it.
Online.
We'll finish it that day.
For physical, if anything arises, my lord, for physical reply from my end.
What do you want? Tuesday you said?
For online, if physical, then my lord, Thursday.
No. Then we'll finish today. You complete. Yes.
So Millard,
But it to my lord, give that my lord order.
You should have given him. Go ask someone to get a printout even now. Give us.
May I go out?
Yes, please go.
Millard, para 2,
Yes.
the writ petitioner initially applied in EWS category to face one examination. The category of the petitioner was treated as unreserved, but in the list of the selected candidates, the category of the petitioner was shown as EWS. However, he could not produce the EWS certificate and accordingly his candidature was cancelled. Though the writ petitioner has specifically submitted an affidavit and informed the appellate authorities on 10th February 2021 that due to outbreak of pandemic, the writ petitioner could not obtain EWS certificate and the writ petitioner has not taken any benefit, either age relaxation or educational qualification on the basis of the EWS category. And requested the authorities concerned to consider the case of the petitioner as an unreserved category, but the authorities did not accede to such request. In such circumstances, the writ petition was filed. It is not in dispute that the petitioner has applied for the EWS category, but he obtained 99 points and requested the authority concerned to consider his case under the unreserved category as the petitioner could not produce EWS certificate. If the petitioner were to be treated as EWS candidate, then by reason of his marks, Compared to the marks obtained by the unreserved category candidates, he would have been merit listed with the candidates in the unreserved category.
How do you say? This is
Now,
just now we have read this, therefore we were
Yes.
waiting for you to come to this. Portion.
Yes.
What do you say?
I say this,
That
Milord.
is a wrong statement.
No, may not be a wrong statement, Milord,
Please,
subject to
sir,
correction.
you have your admitted cases, you have 99 marks.
Yes,
We have gone through the merit list.
correct.
There is not one person below you in the
Right.
unreserved category.
Right.
Not
Milord-
one person.
Milord, the case made out in the writ petition was that after exhaustion of the merit list, since many of the candidates did not turn up, they started calling candidates from the waiting list.
No.
Yes, Milord, that is the
The
case made
merit
out.
list and wait list were published simultaneously.
Simultaneously.
Correct.
Once they started calling candidates
So
for document
therefore, then
verification.
anyone can arise at any time and say that take me in that.
No, Milord,
Why not?
Just,
That will upset the
No.
entire thing.
no, it would not. Just,
This is the way a public
Milord,
recruitment is to proceed.
Milord, just allow me to
Yes.
explain the situation.
Yes,
Merit list and wait list was published simultaneously.
simultaneously, yes.
Subsequently, they started candidates for verification of documents.
Yes.
All the candidates in the merit list did not appear. So they had
These
to
are very
go.
common things.
Yes, now so the second step is
Merely because many did not appear, nobody will get a right.
no.
In this case, because they have prepared a wait list, therefore waitlisted candidates may be considered.
Right.
That is
now,
all.
yes. Now, since while calling candidates from the waitlist category, they called the last unreserved category candidate who had scored lower than the petitioner.
No, they
Milord, kindly, Milord, I'll show
now
from record.
that is how you're trying to present the issue.
Yes.
But the issue has to be looked at from a very different perspective. There is a definite and final result.
Yes.
You find place in a particular result at one place.
Yes.
Can you be permitted to migrate therefrom? That is the only issue.
Yes. Milord, I should be allowed because of the
So
reason.
one
Yes.
judgment on this ground,
Yes, Milord,
that from
I-
a final list of candidates, a person can migrate into another
Milord,
category.
Milord,
One judgment.
Yes, I'll show Milord.
So it,
Yes.
let's come, then that is the only issue.
Yes, Milord,
Then you have a good case.
2024, one
Yes.
Supreme Court cases 448.
Yes.
The Honorable Supreme Court was considering the decision of the UPSC to
Show the judgment.
on failure to produce general category certificate. They were EWS certificate. They were considered as general category candidates.
Sir, Supreme Court
Now, Milord,
passing
before-
an order and High Court passing an order, you have to realize.
No, Milord, I understand the 142 makes
The
a
High Court
difference.
has passed an order which is affirmed.
Milord,
Cannot be, sir. It
Milord,
is by the apex court, must be under 142.
Milord, under 32, probably the lit petitions
Then-
were prepared.
then
Milord,
how-
before looking at the judgment, Milord,
Yes.
kindly take the facts once.
Yes.
Milord, kindly sees. Milord, the wait list.
Only the contempt proceeding has been stayed. It is on my mobile. Next.
You have not got a printout.
Just
Get a
now-
printout. Why can't you get a printout?
Milord, it starts from page 82. Waitlist candidates.
Yes.
Milord would turn over to page 85.
82.
82, the waitlist starts.
Give us a minute, please.
Yes, Milord.
Yes. This is the wait list.
Yes.
And you are at which serial?
Waitlist must be there.
In wait list, his name is not appearing. His name is in select list.
Oh, yes, he's at 147 in the select list.
That was select list, madam. That is why he-
147.
Yes, madam.
Yes, 147.
The select list. Now he is claiming right from the base of.
Yes, you are not in the wait list.
Yes, now Milord, the last candidate whom they have appointed from the wait list is Milord. Serial number 67. Kindly takes page 85.
Yes.
67. Milord, slightly illegible, Milord. 67, Milord would find Sachin Vanot, unreserved, and his marks is 95.
That is why we are saying you want to migrate into unreserved now.
Yes.
Whether it is permissible at this stage.
Blood
That is
para
that-
811 of
that is
Indira
the-
Shawnee.
That is the question we asked you at the very beginning.
Blood para.
It is a settled law, reserved
Blood,
can migrate to unreserved
It's not a case
based
of
on
migration.
performance. It is a case of migration.
Blood, why?
You
why?
want to become an
Subject to
unreserved
correction.
category now
Yes.
because you cannot fulfill the requirement of
Right, now
reservation.
2024, what the Honorable Supreme Court has said regarding
Yes.
EWS. It's only a status which crystallizes upon production of a document.
Correct, you never crystallize that status.
Therefore, the
Although you
result is,
claimed the status.
the consequence is I fall back as a general
So
category.
therefore, the terms of the advertisement means nothing that if you don't fulfill
Advertisement
the
below does not speak of any consequence.
advertisement says if you don't produce the certificate, you will be disqualified.
No, advertisement does not say that.
He has read it.
Yes, I'll read it again
He
for
has
your
read
lordship.
it.
So
Yes.
far as EWS is concerned, I'll read
Every
that.
reserved category.
Yes.
It is there.
Millet, page 31.
If the advertisement has, see, there are many recruitment processes where there is a clause that if you do not fulfill this, you will be treated as a general category.
Right.
If this was an advertisement with such a stipulation, then you would have no difficulty.
Yes. Now, Millet,
This is not
I
the
will
case.
clarify that also. I'll clarify that also. Para 31. So far as EWS vacancies, kindly sees Millet to what extent they have stipulated in the advertisement.
Paragraph?
Page 31 of the advertisement. Internal page 5 of the advertisement, the first paragraph.
So this at 67 in the wait list,
Yes,
what is his marks?
95. And he is the last appointed candidate from the general category.
That we have understood. We have seen the Honorable Single
Yes,
Judge's order. What you have said, we
yes.
have understood.
Yes, now Millard has restricted the scope of the appeal. Millard, I'll just address that
Yes.
question. How far,
That is the only thing
how far
obstacle in your,
whether the consequence.
that is the only obstacle against you
Right.
being very
Right. Now, Millard,
open.
right,
Yes.
Millard, so far as the consequence of non-submission of the EWS
Let us see what
certificate,
where is
yes,
the, yes.
page 31. First paragraph at page 5 of the advertisement, internal page 5 of the advertisement, paragraph 31. EWS vacancies are tentative and subject to further directives of the Government of India and outcome of any litigation. The appointment is provisional and is subject to the income and asset certificate being verified through the proper channels, and if the verification reveals that the claim to belong to the EWS is fake, false, the services will be terminated forthwith without assigning any further reasons, without prejudice to such further action as may be taken under the provisions of the Indian Penal Code for production of fake false certificate. This is not our case since no certificate was produced. The second line, the income and asset certificate issued by any one of the authorities mentioned in the prescribed format as given in Annexure C shall only be accepted as proof of claim, candidate's claim as belonging to EWS. Now, Millard would look into a very important document issued by them.
That is the only, this, you have read as if there is no other clause in the advertisement which covers the exercise of option to claim a reservation.
No, Millard, reservation has a separate stipulation also.
49, my lord. 49 plus 7, my lord. Options.
Please don't do this. This is not done. Come to page 236.
Yes,
Read clause.
clause 7.
Yes, read it.
Option should be exercised by the candidates carefully after going through the advertisement and keeping in view fulfillment of eligibility conditions, educational qualifications, experience, etc. prescribed
Yes.
for the post. Option once exercised shall be final and no change will be allowed under any circumstances.
Correct.
Right. Now, Millard kindly takes their own document. How they have, Millard, acted against this, or they ought to have acted against this. ওই চিঠিটা কোথায় গেল যেখানে বলেছে they're found by DOPT? Milord, page 137.
What is that?
Milord, their communication. Page 137, that is 4th January 2021.
Just a minute, can you please, once again point
One,
out?
137.
No, once again point out that page where you were shown at serial 67 in the, oh, sorry.
Wait list.
The last appointed
yes.
candidate in the wait
Yes,
list.
yes, Milord, I'll show.
All right, we have got it, 85.
Yes, 85.
Yes,
Page 137.
yes.
Milord, it's issued by them, Food Corporation Zonal
That,
Office.
this, they have, this has been placed.
Milord, kindly, Milord, for my satisfaction once.
Yes.
Several representations were received from the candidates who failed to submit valid EWS certificates for the year 2018-19 in respect of recruitment of category 3 posts against advertisement number so and so, highlighting the difficulties in obtaining the category certificates due to various reasons. Since this line is, Milord, is important, FCI follows the Government of India guidelines in the matter of reservation, and the matter was examined in consultation with Ministry of so and so and DOPT. Now, Milord, what DOPT has said. This was, Milord, this Milord would find at 115. Office Memorandum of DOPT. This specifically deals with reservation of economically weaker sections in direct recruitment in civil posts.
Yes,
115.
yes.
So, Milord, it's a horizontal reservation. This, that, Milord, it's not relevant for this. Milord would straight away take 118, clause 7. Adjustment against unreserved vacancies.
100?
118, para 7. A person belonging to EWS cannot be denied the right to compete for appointment against an unreserved vacancy.
Sir, it is a
Personal-
reiteration of the same thing.
Correct.
Reserved can always migrate to unreserved
Right.
or based on the performance,
Right.
not after the result and after being placed in a category.
No, he
This
has,
is during the category. Please read the entire thing.
Milord, second line, person belonging to EWS who are selected on the basis of merit
Please read.
and not on account of reservation are
Correct.
not to be
Who are
counted.
not selected on account of reservation.
So, in the first
You
round,
have been selected on the ground of reservation.
Milord, on the first
Once you
round,
are selected as a round of reservation,
I
how
asked
this
this
will
to
apply?
myself, Milord, what prompted them to select me in the first round as an unreserved category? Milord, kindly seize the
That is
result of
why,
the first
that is
round.
why we had observed when he was arguing, perhaps you have missed your date of affidavit.
Yes,
You
Date-
waited, you tried your level best. And
Milord-
when you failed, ultimately you
Yes.
could not satisfy the authorities for a certificate.
right.
Then you have come forward.
Yes,
Is
yes,
it-
that is an admitted position because, Milord,
It
during the
is, you
COVID
cannot go back
period,
on it.
Milord, during the COVID period, the government of
All
West Bengal-
those persons who participated, they had to submit a certificate for the same period.
Yes,
Don't
and
raise
many
that
people
plea.
failed.
Don't
many
raise,
people
and
failed.
many people succeeded.
Many people succeeded,
So
Milord.
don't raise that plea.
Milord, those who had could obtain the certificate,
So
they have
don't
produced
raise
it.
that plea. It was not an impossibility to be performed.
Now, Milord, even when upon an overall examination of the selection process, your lordships has prima facie found that the last selected candidate in the unreserved category has scored lesser than me.
No, he has not. The
Yeah.
last result was 99.2.
No, the from
25.
the wait list
Ah,
candidates.
wait list is
Yes.
different. That we are not on wait list. We are on the
From the
select list.
selected list, it is admitted position that the last candidate scored 99.
Again, you are submitting, yes, from the select list,
selected list.
99.25.
Selected list.
Correct.
Now, when he has got these marks,
Yes.
and from the wait list, they have appointed candidates till that rank where the marks is lower than me.
No, they have not. They have not.
Milord,
From the
Milord,
select list, you cannot compete with anyone in the wait list.
no, Milord, what is the
You have availed the benefit of
Milord,
reservation.
Milord, I asked this
You
to
have been
myself.
placed
No,
in a select list
Milord,
based on the reservation. Now
Milord-
again read clause 7 which you were reading,
Milord,
page
kindly,
118.
Milord, kindly consider this.
Please again read
On
clause
the
7.
overall selection
Overall.
process,
If this is allowed, then this
does
is,
Milord, the selected list and the wait list Milord, essentially makes any difference.
Big difference, sir. Big difference.
So far as merit is
Big
concerned,
difference.
so far as merit is concerned,
Big difference.
Milord, how?
The
Milord,
categorization, the-
Milord, with deepest respect, Milord.
We
I
we
fail
are not here to
complete
tell
this.
you, still we are here to, we are telling you
And
how.
as
We are not here to tell you, still we are telling you how. Because the classification in the two select lists is based on an inter se evaluation of merit in the category in which you were claiming.
right,
For one person to jump, it will cause a catastrophic,
it would not.
it will,
It would not.
it will.
Because by your
It
order.
has to.
Milord, by the order of this court,
That
order
we have
of this
seen,
court
that
is
we have
one post
seen,
must get
that we have
vacant.
seen, that we have
one
seen,
post must get
that we
vacant.
have seen.
Now, Milord, someone
That
scoring
we have seen.
95 in unreserved category,
Yes.
Milord, from just because he is in the wait list category, he is being allowed. And I, despite
That is
just
a-
because of the fact I have
not just
applied in
because,
the
not
this
just
category.
because that is the
Milord, that is the
procedure.
only reason.
That is the procedure prescribed in
Milord,
the
that is the only reason.
that is a procedure prescribed in the advertisement.
Right. Now, Milord, what is the consequence
And that is
of
the
this?
terms and conditions under which you have applied
Milord, what is the
and
consequence
under
of
which
this?
you have
Milord,
participated.
there was no terms and conditions which Milord could prohibit FCI from excluding a candidate who, despite having applied in EWS category, has demonstrated that a person has been appointed who has scored lower than him. This
Alright,
goes, Milord,
that we have
against para 811 of Indira Shawni. Milord, kindly take 811 of Indira Shawni. Merit
Yes.
cannot be compromised. Just because, Milord, he is a waitlist candidate, he's in the selection list and they have gone for the waitlist, his merit not
Let's
compromised.
see 811.
Kindly consider this, Milord. Milord, I'm sorry, Milord, I'm only carrying one book,
How
Milord.
can you do this?
Milord,
How can you do this?
it was a very.
You are appearing before a division bench and you say sorry. You know you are appearing before a division bench
Milord,
since morning.
Milord, it's a bulky, Milord, judgment. We could not take the print. Milord, it's almost 900 pages. It's aware.
Sir, you
Milord,
could have taken a printout of the relevant pages.
Milord, that's
We
my-
know how to do things.
That's my mistake.
Don't raise such pleas. How do you expect us to consider? What is this? We want to conclude the thing, or for some reason or the other, we are unable to.
Supreme Court reason here.
And if you don't have it again, he will say, I can't come on Tuesday. So this way, no case can be decided.
Milord, only a small paragraph, may I read it out, Milord?
No, you give a judgment. There is a way of appearing. It's not a single bench that I will go and decide myself.
May I go to the stay?
Give him a copy.
Milord,
You continue on Tuesday. We don't know. You come with copy.
Milord, I will.
Come with a second copy of the book.
Right, Milord, I will.
Thursday, is it possible?
Yes, Thursday it can be done.
Deeply available.
No, Thursday it will be too late.
But it will be closer to the,
Too late.
Milord has extensively heard it, Milord, Tuesday.
Wednesday at least, my lord, Wednesday.
Wednesday we can do it. Yes.
For that, I can
For
plan.
further consideration of submissions on behalf of
Number 10.
Lordship, direction was given to submit the informal paper book.
You have served.
No, Lordship, no, Lordship.
Who is he? Who is your friend appearing? You know?
Shubham Ghosh.
Give him. Informal paper books are being filed. The learned counsel submits that he would serve copies on the learned counsel for the respondent, who
Lordship, I made 2 copies of said affidavit. Your Lordship, I've annexed the photocopies of the said drafts. I have the original with me at your Lordship.
Lord, I dispute, seriously dispute, because the agreement was held with me, with one Imran Hussain বিশ্বাস. Now drafts were purchased, one by Greaves Realty Private Limited, another by NBC Trading, and all these things. Who are the persons? I don't know.
Those are the company of the say.
No, you have not written anything like this.
Your
Because
Lordship, the demand draft.
right from the beginning, the agreement was executed long back.
what is the dispute? Tell us first, what is the dispute?
Dispute, my lord, the agreement was executed, page number.
Forget about page, tell us.
October.
Forget about page, tell us what is the issue.
Agreement was executed on 9th of October 2023
For
for sale of a property. At the price, consideration price was 1,25 lakhs. And the time was the essence of the contract. And it was stipulated for a fixed period of 4 months. Time expired because he didn't have sufficient money, adequate money. The agreement was cancelled and the advance money was returned back and he received it without any hesitation. He received back the money. Thereafter, he filed a suit and got an order from the lower court. That's being challenged
so
before
the
your
suit
lordship.
was decreed in his favor. The
This is an injunction.
Status quo was given. The property was held, preserved rather. But there is no existence of the agreement.
oh, so this is arising out of an interim order.
Interim order.
Interim order of status quo.
Status quo. And no third party
But
interest.
my lord, this I submit before lordship. There are 2 decisions of the Honorable Supreme Court. Because he didn't have sufficient fund.
Now, your Lordship, if I may.
So why this, so how this occasion arose for submitting drafts here?
Your Lordship,
We
prior
went
to-
on marketing the same, for marketing.
let me submit.
You
Let me submit.
have some, please try to listen to us also. Merely loud voice submission is not going to make any difference.
On the last.
We are asking you how the occasion arose to deposit this 50 lakh rupees. Every submission very loudly made does not.
Order, last order.
What is it?
Justice
Tell us.
Banerjee-
We are
Justice
trying to
Banerjee-
understand things.
Justice Banerjee categorically asked him, do you agree to purchase the property? Do you have the sufficient fund? Well, to show your bona fideness, you deposit rupees 50 lakhs right tomorrow or day after tomorrow.
So there is an order of this court.
Yes, this court. 50
What is
lakhs.
the date of the order?
The date was 9th of April 25. we want to test the bona fideness of the respondent. Let the respondent produce the court a bank draft of rupees 50 lakhs drawn in favor of the appellant. On 11/4, he failed. He took time, another.
No, your lordship, that is a false submission.
Please, yes, on 11 he failed.
Thereafter, the order passed on 11/4. In the event the respondent does not do so, the interim order passed by he has obtained in the lower court in the suit filed by him before the Lorraine trial court may be liable to be vacated.
On 11/4.
Yes. The order passed on 11/4, 9/4, 11/4.
On the 10th of the April, your lordship, there was a statement.
No, but then now you are saying that these drafts are not purchased by him.
Yes.
What difference does it make to you? It's the
I
question of money being
submit,
deposited.
Lordship, kindly appreciate.
Whether he has
person-
taken it on loan, he has
person-
given from his pocket, what he has done, how are you?
Person with whom I entered into agreement, he did not have sufficient fund.
No, he is the same person.
1 crore 25 lakhs. He
He-
only purchased from other persons.
He is
collected
not
the
the,
money.
he is not the same person.
He's not the same person. The NB Greaves company, NB Trading, the same person.
Lordship,
He is not the same person.
Oh, he's the same person.
Problem is you are only interested in saying, you are not
He is
interested in
not
listening to anything. And that
Sorry.
will not in any way help you. You can keep shouting.
The problem is, my lord, okay, if, all right, my
What
lord,
difference does it make? We are asking you, there is an order. These two orders you have never challenged. He has complied with the order. He is giving the drafts, whether he has arranged it from some loan, from some company. How are you concerned? They will not claim any right. The persons whose name is appearing on the draft, they cannot claim any right.
my lord,
If Mr. X has purchased the draft for him, the right, he will not claim any right. He cannot. It
even
ultimately,
if, my lord,
it will be between you and him only.
my lord, even if I accept the same,
Yes.
my only grievance, your lordship, that he did not have adequate fund at the time.
That is all right. That is yet something which
Number.
is yet to be
My
decided.
second submission, my lord, second point of submission.
We are not going to decide these issues.
After execution of the agreement, after paying the advance amount, he went on for marketing the same and entered into agreement.
You say 4 months was allowed for. What is the draft is valid till which date? 3 months or 6 months?
For 3 months.
3 months.
So 3 months.
3 months.
3 months.
It will lapse in 3 months. Then what he will do then?
No, your lordships,
My lord,
actually,
within these,
prior
yes,
to
may I make submission?
Please, yes. Yes, please.
Within these 3 months, he pays the balance consideration price along with these 50 lakhs. I'll be executing deed of sale in his favor.
your lordship,
But one thing, another prayer, humble prayer, your lordship, that within this, for this last 1 year, I'm supposed to get 1 crore 25 lakhs. If any interest be paid to me.
your lordships, with regard to that.
You save that for the last. First, you see what comes through.
Your lordships, may I?
Because this huge amount,
We have understood
he has
what
blocked the entire.
we were wondering why you have not said so long. You are saying all things, but
That
this
is-
you are
that
not
would have
saying.
been my last submission, your lordship.
Yes.
That would have been my last submission,
Now-
because I'm ready to execute deed of sale. I'm ready. Within 3 months, let him.
So he has, his bona fides has been tested.
Yes,
You are also expressing a bona fide.
yes, my lord.
Such a good situation, why you are litigating? Why not go for mediation?
Let your lordship mediate it.
This-
Within 3
this-
months, I'll do it. Let him pay the balance, come out.
Lordship, prior to that, with subject to the interest that the learned counsel for the petitioner has been pressing. Your lordship, with regard to the.
We are not talking of interest. What is the date of the original agreement?
It was on 9th of October 2023.
23.
3.
Now,
And
so
2 years
4
gone.
months, 4 months, your lordship, 4 months is subject to the petitioner submitting all the required documents for the said land. It is mentioned, specifically mentioned in the clause.
therefore, there is no scope now for any dispute. If both are bona fide, honoring their commitment,
No, your
then why don't you
your
resolve?
lordship, there is one more dispute. Your lordship.
Yes.
The dispute lies is they are claiming that they have refunded the 43 lakhs. Whereas I'm stating I have not received a penny more than 14 lakhs rupees in my account. 14 lakhs. The dispute lies there.
Earlier you had paid 43.
43. I have received
out
my
of
account
120
14 lakhs rupees.
Out of 125, according to you, you have paid 43 and now
43,
50.
now 50.
So 93.
93. Out of which I have, they have refunded 14 lakhs in my account.
19 lakhs. According to the agreement, I'll come to that. If it fails to perform the contract, you will lose 10%.
Your lordship, please, the council, please could read the entire clause, not handpicked provisions. Your lordship.
Clause number 11, if the second party fails to take registration without a reasonable cause within the stipulated period, then first party shall have the right to cancel the agreement and deduct 10% of the advance amount.
Your lordship,
And they- after deduction, the
clearly
amount
speaks about the
that was
difference of
paid
time.
back. After deduction of the 10%, that was paid back and he received it without any agitation.
Switch off the live stream. See, in such
Respondent number 3, they were left, my lord. They are left. Respondent number 2, 2, 3, 4.
Lord is also representing the petitioner.
আজকে অর্ডারটা এলে চিঠি করতে হবে, পিটিশন করতে হবে, অর্ডার হয়েছে বলে।
সেটা ওই দিনে করে, তো আজকে ডেটে যদি